The defense lawyer asked an innocent-sounding question to my client during the course of a pretrial question and answer session known as a deposition. The attorney said, "Hey, did your loved one have life insurance at the time that he died?" And you know what I said? I said, "Objection! I direct you not to answer that question. You know better than that, counselor." You want to know what this is all about and why I was well within my legal right to tell the defense attorney to take a hike with that question? Come join me on this walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, my client brought a lawsuit on behalf of her husband for medical malpractice and wrongful death. She was claiming that the doctor who was caring for her husband was careless and that his carelessness caused and contributed to her husband's death. Now, during the course of the lawsuit, you should know that each side has an opportunity to question each of the people involved in the lawsuit to learn a bit about what happened and why. So now this is known as a deposition. This pretrial question and answer session takes place in our conference room where my client is being questioned. The defense attorney will come to our office, we'll go into the conference room, and now my client will sit there and be asked questions. Now you should know something really important. This seemingly innocent question and answer session carries the same exact weight as if my client is testifying at the time of trial. There's only two real differences. The first is that there's no judge there. The second is that there's no jury there. So you might be wondering, how can this carry the same exact weight as if this is happening at trial? The reality is that this is sworn testimony. Now, how do we know that it's sworn testimony? Because before my client is asked questions, they are sworn to tell the truth. Now, there will be a court stenographer there to record all of the questions that she is being asked and all of her answers. And those get put into a booklet called a transcript. And that information, those answers to those questions, represent her sworn testimony. So it is exactly the same as if she is testifying at the time of trial. All right, so now this is a wrongful death lawsuit, where now she is claiming that because of this doctor's carelessness, now her husband died. And the defense attorney has a right and an obligation to go ahead and ask questions about what she knows concerning the events surrounding her husband's medical care and treatment, as well as any conversation she participated in, and that's perfectly acceptable. But now, during the middle of this deposition, and I knew this was going to happen because it happens in probably 99% of the time where a defense attorney is questioning my client in a wrongful death case. The defense attorneys have an annoying habit to ask my client in these wrongful death cases whether or not the person who died had life insurance. Now, it comes across as a seemingly innocent question, right? Hey, by the way, Mrs. Jones, did your husband have life insurance? And the normal reaction is to say either yes or no. But why did I get so upset and why was I so angry that this defense attorney had asked my client whether or not her husband had life insurance? I'll tell you why. Whether or not my client had life insurance has nothing to do with the claims that we have made, which are that the doctor was careless. So whether he had life insurance or not has nothing whatsoever to do with the claims that we are making against the doctor and the hospital for the fact that they were careless. That's number one. Number two, whether he had life insurance has nothing to do with the damages that we are claiming that the doctor and the hospital are responsible for paying because of his carelessness. So think about that. When we bring a lawsuit, we are seeking money as a form of compensation for all the harms and losses and damages that occurred because of this guy's carelessness. So if we are successful and we're able to show that we are more likely right than wrong, that the doctor was careless, causing harm and injury and ultimately this person's death, now the doctor and the hospital are required, in fact they are obligated, to compensate my client and his surviving family for all of the harms and losses and damages that they incurred. Now, whether or not he has life insurance has nothing whatsoever to do with the amount that they are legally obligated to compensate the family for, which is another reason why I get so angry and upset when the defense attorney asks such a ridiculous question. So not only does this question and the answer have nothing to do with the claims that we are making in the lawsuit, it has nothing to do with the amount that the doctor and the hospital may be legally obligated to pay to the family for damages. And also, here's a third reason. It has absolutely nothing to do with the defenses that are being raised in this case. Now, what do I mean by that? When we start a lawsuit for medical malpractice or wrongful death, the defense will typically raise a number of arguments to say, hey, I did nothing wrong. That's typically the very first defense that they raise. They say, hey, why are you suing us? I did nothing wrong here. That's number one. Then they turn around and say, you know what? If I did something wrong, so did you, Mr. Patient. You did something wrong. They point the finger at the patient for causing their own injuries. Then they turn around and say, okay, if I did something wrong, and maybe you did or didn't do something wrong, whatever I did didn't cause or contribute to your injuries. That's known as causation. So they argue not only that there's no liability on their part, they did nothing wrong, then they argue that even if they did something wrong, whatever they did didn't cause harm or injury to the person who died. And then they say, if we did something wrong and we caused you harm, the injuries you suffered really aren't as bad as you claim them to be. Those are the typical defenses that we see in these medical malpractice cases. All right, so now let's get back to the key issue that I've raised in this video. Can they ask the question about whether or not the person who died had life insurance? And if so, what does that have to do with the defenses that they have raised in this case? So the only real reason why a defense attorney would want to know if this person had life insurance is because they want to know how much money the family has received because of this person's death. So you might be thinking, wait a second, why would they want to know how much money the family has received? I'll tell you why. Because they want to try and show and use this during the course of negotiations to be able to argue, now, hey, listen, why do you need this much money? The family has already received X number of dollars from life insurance to compensate them for this person's loss. Why do you need all this money from us? That's the only real argument that they would try and make if they learned about whether or not there was life insurance involved here. They can't use this at trial. Can you imagine if a defense attorney used this argument at the time of trial? Ladies and gentlemen, you can't give this family $5 million. Why? Because he already received $1 million from life insurance. So therefore, his family should only get $4 million that they're asking for. No, no, no. That would be an outrageous argument. That would be objectionable. And in fact, I think it would be totally inappropriate. The fact that this person had a contract, a binding contract with an insurance company, to pay his family in the event of his death has nothing whatsoever to do with what the doctor in the hospital did, has nothing whatsoever to do with his death, has nothing whatsoever to do with the amount of money that they are legally obligated to pay to the family. Whether or not this guy had other assets for his family, whether or not he owned homes, whether he had stocks or bonds, whether or not he owned property or cars, has nothing whatsoever to do with the claims in this case. But for them to ask whether or not my client had life insurance is outrageous. And I get so upset every time I hear this stupid question. So I turned to the defense attorney and I said, objection. I direct my client not to answer that question. That is palpably improper, and you know that, counselor. And you know what the attorney said to me? Oh, you can't tell me what I know. I said, listen, I'm telling you, the law clearly states you cannot ask that question and you will not get an answer to that question. You have a problem? Go take it up with the judge. Let's see what happens. And what's most remarkable is that the defense attorney knew it. This was an experienced attorney, but I knew she was going to ask the question anyway. So why do I share this great information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases, these accident cases, and even these wrongful death cases here in New York. You know, I recognize if you have questions about your own matter but have not yet started a lawsuit, and your matter happened here in New York and need answers to your questions, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.